Breaking news coming in is how the Supreme Court has dismissed the plea filed by Nirbhaya's parents, who along with Subramanian Swamy had approached the highest court to treat juvenile accused in rape cases and other heinous crimes as adults. They had pleaded that juveniles should be tried in regular courts depending on the severity of the crime and should not be shielded under juvenile laws. Let's get a word from our correspondent Jaskirat Singh Baba, who's been tracking the story for us from outside the Supreme Court. Jaskirat, what was the observation made by the Supreme Court while delivering this order?
Well, they believe that this is a job of the legislature to change the laws and change the rules, and this is pretty much in line with what the Supreme Court has been saying, digital activism, for at least the past couple of years. So we are actually noticing a trend of sorts over here. Now, while of course sympathizing with Nirbhaya's parents, as well as agreeing to a little extent with what Subramanian Swamy was suggesting, but at the same time suggesting that it is not the role of the judiciary to make amendments in law, it is for the legislature, because they are the actual elected lawmakers and representatives of the people and the society. So it's their job to do so, and in that manner and with that reason, they refuse to indulge themselves as far as amending the Juvenile Justice Act is concerned. The main arguments from Subramanian Swamy was that India was in a rush. In fact, he has suggested that the erstwhile NDA government as well as the subsequent UPA government had not paid enough attention and was in a rush when they drafted the Juvenile Justice Act and later on implemented it, and they made it a very black and white affair where people below the age of 18 could do anything and then were let off with a maximum of 3 years of imprisonment, and those even a day above 18 were treated in a different manner as an adult. He said that there's a grey area in between, and the mental maturity of a person should also be accounted for while prosecuting that person, even if the person is under the age of 18. But all that is irrelevant right now because the Supreme Court refusing to take any initiative with that regard and dismissing the plea filed by Nirbhaya's parents as well as Dr. Subramanian Swamy.
All right, so the Supreme Court dismissing the plea filed by Nirbhaya's parents and that of Subramanian Swamy regarding treating juveniles accused of heinous crimes as adults and handing them strict punishments. Jaskirat, I also wanted to ask you, what are the other arguments that were made by Nirbhaya parents? Was a reference to the Shakti Mills gang rape case. Did that also come up?
The arguments took place in this judgment has actually been reserved for almost 2 months now. So those cases, that specific case, only found a slight mention, but there were other cases that were mentioned. The statistics that were shown to show the number of juveniles who are indulging in serious and heinous crimes has only increased in the last few years, and especially in the last specific decade or so. So they were relying on those statistics. They had legal teams, some people, some lawyers who were appearing for them pro bono, as well as other people who would also from NGOs and other lawyers from faculty members of law school who had aligned with them and tagged them along with them, who were backing them up with statistics, data and legal analysis to reiterate the fact that there is in fact a precedence, and there are some other developed countries, democratic countries, which have in place a system to try a juvenile for heinous crimes and punish them as per the crimes committed. However, at the same time, we had the government which is opposing it. We also had some NGOs who were in favor of child rights who were opposing it, suggesting that the infrastructure or the criminal jurisprudence in the country is not mature enough or not in place per se to actually make that distinction or distinguish as to who exactly is mature, mentally mature enough to be tried as an adult and who isn't, which is why a cutoff age of 18 is required.
All right, Jaskirat, does this mean that the Supreme Court is actually putting the onus on elected representatives to make changes in the law if required?
Well, that's right. Like I said, there is a growing trend over here which we have seen in the past few years, especially if we go back to the Nas Foundation judgment with regards to Section 377. Even there, the Supreme Court said that this is a job of the Parliament, this is a job of the legislature, which is almost correct in a manner of saying, because the Juvenile Justice Act was ratified and then later on passed by the Parliament in agreement with all the members of the Parliament. So the Supreme Court is suggesting over here that since that is the case, that is the origin of the law, if there are any amendments that need to be made, just like the Criminal Amendment Act in the aftermath of the Nirbhaya incident, where the harsher punishment for crimes which are violence against women and crimes which are sexual in nature or rape charges are concerned. In the same manner, the Supreme Court suggesting that the legislature's role is involved over here to make those amendments and not the Supreme Court to do so.
All right, Jaskirat, stay on with us. I believe we can also go across to Subramanian Swamy, one of the petitioners in the case. He's joining us on the phone line. Mr. Swamy, the Supreme Court dismissing your plea, your first reaction?
Well, the The Supreme Court took the view that they cannot accept my interpretation of the law, that only the Parliament can. So they said they didn't have a power to do what I wanted them to do. What I wanted them to do is to read the Indian Juvenile Act in the context of the United Nations Convention for the Rights of the Child and the Beijing Rules, which clearly provide for the emotional and physical maturity of a person in heinous crimes. And I said that, in the case of the kind of rape that took place on Nirbhaya, as well as if a terrorist tomorrow at the age of 17, 11 months and 29 days commits a heinous crime, he would also be then sent only for 3 years and in a special remand home. So it leads to a paradox. So court, while accepting all that, said that, but we don't have the power, and this has to be done by Parliament. So I'll wait for the new government and see if I change the law.
So, Mr. Swamy, you're saying that the Supreme Court putting the onus on Parliament. You're also a member of the Bharatiya Janata Party. Is this something that you'll be taking forward as a politician?
Yes, I certainly will canvass within the BJP. I've already had in the context of the Nirbhaya case, I've discussed this widely with not only BJP senior leaders but also with the Sangha Parivar people. They all feel that there has been a sudden rise in the number of juveniles committing rape and gruesome rape. It just happened recently in Bombay also in that Mills area. So, and tomorrow Kasab also had claimed after the 26/11 that he was a juvenile. But since he didn't have a certificate, so they subjected him to a medical exam and said, no, he's an adult. So tomorrow Pakistan can train people under the age of 18 and send them here, and these people will be out in 3 years.
Absolutely. So, and Mr. Swamy, do you also see this as really a travesty of law, because the role of the 17-year-old in this Nirbhaya gang rape case was considered the most heinous, which is why the parents had also approached the top court?
Well, the parents came after I came. I was the petition number 1. They sort of, their case was filed much later, and then it was tagged along with mine. The fact is that they were raising the question of the constitutionality. I never raised the question of constitutionality. I only said that the law was badly drafted. It missed out the key phrases of the United Nations provisos, and therefore the court should read into it. The court, I thought, had the power, but they said no. In this particular case, we don't have the power, and this must be done by Parliament. And I suppose since they have said so, and the new Parliament is not far away. There is still hope that we'll change the law retrospectively.
All right. Mr. Swamy, I also wanted to ask you, you said that you actually thought that the Supreme Court could make the required amendments. Why is it that you thought that it would be best to approach the Supreme Court? And in your view, do you think this is something that the Supreme Court could have taken a strong stand on?
Yes, I think the Supreme Court had wanted. It appears that they didn't want to. Maybe they thought it will create chaos. I don't know, because all the trials which have been concluded would have to be reopened. They felt that perhaps it would cause a big chaos. And I don't know what the reason, but there is a doctrine called doctrine of casus omissus, and the doctrine of the interpretation of statutes, where they say that the court can interpret the law in a way which brings it consistent with the social situation. So therefore, if they wanted to do it, they could have done it, but they were obviously reluctant. But they have given a very large judgment. I'd like to read what all they have said.
All right, Mr. Swamy, thanks so much for speaking to Headlines today. That was Mr. Subramanian Swamy of the BJP petitioner number 1, who had approached the Supreme Court asking for juvenile accused in heinous crimes to be treated as adults. The Supreme Court has dismissed the petition, saying that the onus really lies on elected representatives and a change can only be brought through by Parliament. Thanks so much for speaking to us. Thank you also to Jaskirat Singh Bawa for getting the latest on developments.